of give peace a chance. Under the pretext of give peace a chance, as we have seen. The last 3 decades have shown clearly that without addressing rules of international law, IHL, accountability, then the worst is yet to come. And we were saying this all the time long, that the worst is yet to come. And we discovered that there is still worse than what we expected. And now, again and again, we say the worst is yet to come, unless international community has to address accountability seriously. Gaza, the legal center of Gaza, is an occupied territory before and after Oslo, and definitely before and after the unilateral disengagement from Gaza by the Israeli forces in 2005, and definitely before and after the taking over of Gaza by Hamas. So this is the stand of ICRC, stand of international community, or the bulk of international community, Gaza to continue to be an occupied territory. Consequently, IHL, namely the Geneva Convention, is de jure applicable, and Gazans as civilians are protected, and their properties as well are protected. So Israel launched an offensive in 2014, and again, without going into details, because I think accountability should need sort of autopsy on the whys and some details, which I think we could have time to elaborate more on this. And the 2 main issues to be addressed directly when it comes to accountability from the side of the Israelis: first, the amendment of the torts law, amendment number 8 of 2012, and then the MAG and the mechanism that is mandated to investigate complaints submitted by victims in Gaza. To sum up, I believe the Israeli judiciary is the only, it's very unique. We have very much engaged with the judiciary. It's quite reasonable system, but when it comes to the occupied territories, it's a completely different story. And I think it's really mission impossible for victims to pursue justice through the Israeli legal system. All barriers are there, to the extent that it's the only case I ever heard of where the system boycotts the victims. Usually victims boycott the system, claiming that it's biased, it's not independent. But in case of Israel, victims have done their best to pursue justice through the system, and we engage heavily with the office of the MAG as well as the judiciary. However, it's in most of the cases, which we are going to elaborate more, that all complaints that were submitted almost have closed without executing criminal investigation. So the offensive was launched in 2014. It was a very large scale aggression. No place, there was no safe zone in Gaza, as you know, when F-16 war jets just occupied the sky of Gaza, bombarded everywhere, in the heart of the most populated civilian areas, and has been repeated recently in last May, as you know, that, and in the heart of densely quarterhoods, civilians were attacked, homes were attacked, and amongst them the multi-story building of Ziada family. Just one case amongst many cases. They know in advance that it's civilian entity, civilian area, and people who are there are civilians and must be protected. Principles of proportionality as well as discrimination, proportionality, has been dramatically violated, which are the 2 basic principles of IHL, which I think we'll talk more on this when we have more time. So this is the context where Gaza was and still. There's the speakable and the unspeakable, the dynamics of everything on the set. I think the offensive of 2014, with all the crimes that were committed, as was clarified and set out by the Commission of Inquiry that was established by the Human Rights Council and the different NGOs, were alarming, that because accountability has not been in the order of the day, crimes were committed. And now victims are further than any time to achieve the minimum requirements for justice. If justice cannot be achieved through the Israeli legal system, then what to do? Where can they go? Imagine someone, his home was destroyed by an Israeli airplane in 2008, and then he rebuilt it and was again destroyed in 2012. 2014, a family member were killed, and 2021, another incident took place, and no justice yet has been achieved. I think it's a moment of the truth where international community should here intervene, and courts, national courts of universal jurisdiction should address the matter, because it's now, those are the only resorts vis-a-vis victims, because without addressing justice, because justice by the end of the day is not an act of revenge, and should not be, and will never be. If we consider, Palestinians as well as Israelis and part of civilized nations, then they should accept the rules of the game and refuse what they refuse and accept what they accept. Justice is on top of the agenda of politics, international engagement, humanitarian aid, and that's why it's without executing justice, I think peace and security, not only regionally but internationally, will be dramatically jeopardized. Thank you.
Thank you very much for this first introduction and a general picture of the violations of international humanitarian law and the lack of access to justice. I think we could come back to that if people want to know more clearly what the legal and the practical obstacles are for people in Gaza to enter the justice system. May I ask Jeff because Isam, you say a lot depends on the international community. People in Gaza depend on other jurisdictions than the Israeli jurisdiction to have access to justice. Jeff, could you describe a little bit what in the last decade have been the developments in terms of accountability, the fight against impunity, both at national level outside Israel, Palestine, and in the at the international level, for example, with the International Criminal Court? What are the trends? What are the alternatives?
Yeah, well, that's a really good, pertinent question. And you already pointed to the most significant development, which is indeed the ICC's determination that it has jurisdiction over this matter. This is something that was a subject of a very exhaustive review by the pretrial chamber of the International Criminal Court to decide whether it even had jurisdiction to consider these crimes. And the conclusion at the end was that it did by the pretrial chamber. So that is probably the most significant development of all. There, of course, have been efforts over the period of many, many years, decades even, to try to seek justice at the national level, in Belgium, in Switzerland, in Germany, in the United States, in many different countries around the world, both through criminal claims and through civil claims. For example, there's a case in the United States trying to hold a company accountable for its sale of tear gas, which was deliberately used to torture Palestinians and to harm them in a way that wasn't intended according to the manufacturer's instructions. Well, again, I speak the absurdity of this case because the reality was that it was killing and maiming Palestinians. Various creative uses of the law in different parts of the world have resulted in incremental advances, but really the decision by the pretrial chamber and the ICC is a major game changer.
Can you elaborate a little bit about the developments within the International Criminal Court, the most recent developments with respect to the Gaza bombardments of 2014 in particular?
Well, what used to be preliminary inquiries is now an official full-scale investigation. Of course, the ICC has just had a new prosecutor. That is also a very significant development because a prosecutor is going to have to find his feet. He's going to have to develop his staff and program for operating in the coming years. So it is going to take some time anyway. Whether it's a case of Palestine or any other case that the ICC is handling, because it's, of course, also many other cases that the ICC is handling. But there is no other case which is as politically sensitive as this one. There have been threats by countries literally to try and shut down the ICC, to defund the ICC, particularly coming from the previous administration in the United States. So indeed, as Issam Yunus has highlighted already, politics is absolutely core to all of this. So there are legal developments, and there are significant legal developments, but the politics around this, including countries which actively tried to object to the ICC having jurisdiction over Palestine, are pretty formidable. And you can definitely imagine that the ICC is going to struggle to operate under these really difficult political circumstances.
Thank you. I would like to turn to Kate, because the problem that we see, sorry,
You can talk.
the problem that we see with respect to Palestine, Israel, is not limited to that armed conflict. And we see that, my question is, isn't it so that if you look at the position of the individual in international law, and the agency of the individual, like we have Ismail Ziada in this case, is the weakest if we talk about international law in the context of armed conflict. Is that so, and why is that so? And this is the last question, general, before we really plunge into the details of the case itself.
Right, thank you. Well, fundamentally, war is considered in international law and just by states themselves as a state-to-state affair. States fight with each other. They don't really consider themselves fighting against populations. They consider themselves fighting against states and states fighters, or sometimes non-state fighters. Now, this leaves civilians, which in modern wars are the vast majority of those who are injured and killed in war, in a peculiar, or what now begins to feel like a very peculiar situation. Because if we ask ourselves, do civilians have any type of legal agency in relation to the war that their states or states carry out, we see that their position is extremely precarious. On the one hand, this is quite logical. If it's a state-to-state affair, states, governments, armies are locking horns with each other. They're causing a lot of damage. Afterwards, they might make some kind of reparatory gestures to each other. They might not. Civilians who are accidentally killed in the course of war have very often been categorized as collateral damage. This is a term you've probably all heard. It's a strange thing to think of very large numbers of human beings as collateral damage, but that is generally how civilian deaths and casualties in war are considered. The idea is we didn't kill them on purpose. We were busy trying to kill their fighters or to disable the state. It's a war, there's fighting, there's damage, people get killed. By and large, in international law, in international humanitarian law, states do not consider themselves obliged to address the suffering of civilians whom they kill. Now, that might seem surprising because international humanitarian law does include provisions which are designed to protect civilians. For example, the Geneva Conventions, which most people who follow a little bit war and the laws of war will have heard about. One of the Geneva Conventions is especially dedicated to provisions protecting civilians. But it turns out that how does it protect civilians? It protects civilians by prescribing behaviors that are allowed for militaries to undertake and prohibiting other types of behaviors. So very simply, armies are not supposed to target civilians deliberately. However, it does not go so far as to give any agency to those civilians to say, look, here are the protections. If this goes wrong and you suffer massive damage, this is where you can go to get some redress for it, to get even recognition of the wrongdoing, to get an explanation what happened. It doesn't go that far. Claimants and states and lots of people and scholars can be heard arguing that international humanitarian law protects civilians, but I would argue that it does so only in the form of making a kind of disciplinary law structure that armies must obey. It essentially says, our soldiers must behave like this. If they don't, we will punish them. It does not say, you, you other states may punish them. It does not say, you civilians, you have rights here. If your rights are violated, you may claim recompense. It does not say that. It says, this is how you are supposed to behave. Now, let's just accept that for how it is at the moment. In parallel to this humanitarian law, which is essentially the law of a war, how soldiers are supposed to behave, we have human rights law running along in parallel, a relatively recent development, let's say mostly a post-1960s development. In principle, human rights provide everybody with the right to have their right to life and their physical integrity protected. Some human rights instruments also provide explicitly for a right of claim, a right to bring a complaint somewhere after something has happened to you. Not all of them do, but some of them do. The question now becomes, how is it possible that these two systems coexist? How is it possible that we all have a human right to life, to not be killed and to not be injured, to not be physically violated, while a humanitarian law is likely to call us collateral damage if it all goes horribly wrong? These two things don't really rhyme. It's in this modern context in which these two systems exist next to each other that claimants like Ismail Ziada and others in other states are beginning to come to courts, national courts, and say, how does this work? How can it be that my whole family's house was destroyed in its entirety with 6 civilians inside it? And the explanation given is that the Israeli army was trying to kill one Hamas operative. Where does that fit in humanitarian law? Is it not a violation of the humanitarian law which says you are not allowed to willfully kill civilians? You are not allowed to disproportionately kill civilians. In other words, is it legitimate if you're looking for one member of Hamas to kill 6 innocent civilians? It's a 6-to-1 ratio. Is that proportionate? This is a very legitimate question, I think. Everybody who's interested in this type of war, this type of law, feels that this is a very legitimate question. But it's not an easy question to answer, and this is what we will get to see more and more of as we discuss the case. And Cedric Reingaard will give us a lot more of the technical detail about what makes cases like these very difficult. But what I hope I've done is show you the logic that sort of puts the situation of such a claimant between or among two somewhat overlapping but really parallel systems of law, and might very well leave him without any recompense at all. His one hope is to go to a state, in this case, the state in which he lives, of which he is a citizen, and say, there is no other place for me to go to have this matter properly investigated, or at least considered, to have it considered by a court. Have there been crimes committed here? So far, at the first level of the case, the court was not prepared to go so far as to consider this question. And this has to do with 2 knotty, difficult legal issues that Cedric will begin on shortly. The question of the immunity of states, meaning that, generally speaking, one state is not susceptible to be having its conduct judged by another state. In other words, states are shielded from each other's judgment. This is what we call the immunity of states. The other knotty question is a general question of jurisdiction. Why should a Dutch court have jurisdiction over a case which involved the Israeli state causing harm to Palestinians in Palestine? You might ask, what's it got to do with Holland?
Okay, that's a good question.
Voila.
The Netherlands. Cedric, what does it have to do with the Netherlands? How come a Palestinian claimant enters a Dutch courtroom? On the basis of what? Explain a little bit the law that allows this claim, what the claim was, and perhaps you can say a little bit how the court in its first instance responded and what the decision was about. Both of you have written articles about the first decision, but let's first start how that case arrived in a Dutch court.
Yeah, so the question then really is,
Microphone.
yeah, okay.
We should,
No, no, it's okay. We're good.
it should stay in the middle?
No, it's
No,
good.
no, it's good. It's just we're using the microphone here.
Yeah,
So.
all right. Good. So I think, yeah, there was a very nice bridge you folded. Also, thanks, Frederica, for the question. So the question really is, what does this case do in a Dutch court indeed? Because we're talking about harm, which was done for all intents and purposes in Israel by Israel against people from Gaza. So the link with the Netherlands at first sight may appear to be rather tenuous. So we have Ismail Ziada today with us, living in the Netherlands and having Dutch nationality. So you do see there is some connection, but under private international law, which governs these civil cases, it's not normally enough, right? But the good news is that in the Netherlands, we have an article, it's called Article 9 of the Code of Civil Procedure. If ever you're interested in reading that, it's quite a complicated article, but it really offers a forum of necessity, as we call it. It offers an exceptional forum to avert a denial of justice. So this is what you find in Article 9, and there should be, and in Dutch, I have it here, voldoende met de rechtssfeer van Nederland verbonden, which sort of means there should be like some connection with the legal sphere of the Netherlands, but this is not further defined. So nationality or residence of the plaintiff could perhaps suffice. It's a bit left to the discretion, you could say, of the judge. Now, of course, is there does the plaintiff face a denial of justice elsewhere? I think this is a very important question. And then you would really have to look into, I think, the quality of Israeli courts. I was always operating under the assumption that Israeli courts, that Israel was a rule of law-based society. You have courts which are independent, and I've written that also in this NJB article, to which reference was already made. But of course, I'm not from the area itself, and we've just listened to Issam, and Issam basically saying that, well, these cases in Israeli courts proper don't stand any chance of success. So you really have to go elsewhere. So such a case could, in principle, be successful under Article 9 of RV in Dutch courts, and there have been precedents for this. There's one case called El Hajouj, that's about 10 years ago. There was a case brought against Libyan officials, also in relation to torture, so also an international crime. So a successful case, of course, whether you get the money in the end, that's another question. So in a way, it's a symbolic judgment, but as such, it could already be a moral and legal victory, obviously. Now, a criminal case was not possible in this case, because for that, you need the presence of the presumed perpetrators. Now, the presumed perpetrators, the Israeli generals, are of course in Israel. And so they're not territorially present in the Netherlands. So that was, well, a non-starter, I would say. So universal criminal jurisdiction was not the way to go here. So this is why they tried the civil litigation, and you don't need the presence of the presumed Israeli offenders, and the presence of the plaintiff relative of the victims might be enough. But the court didn't really touch on the jurisdictional issue, touched rather on the issue of immunity. So maybe Kate, was that something that you wanted to explain first, and then I'll go back? I don't know if it.
Yeah, maybe you can briefly describe what the court's decision was about, and then, like I said, both of you have critically written about the decision that came out in January last year. So perhaps you could say a little bit about, short, what the decision was by the court and your critical observations.
Yes. Briefly, the court decided that the Israeli state would have immunity from any kind of judicial investigation of its conduct in this incident, and concluded that as a result of that, the two high military officials of the Israeli state would also have immunity. They simply concluded the one from the other. They said the state has immunity. A state cannot act but by the conduct of its officials, Therefore, when its officials act in its name, they too have immunity. Now, there is a type of immunity, a specific type of immunity that is supposed to attach to the conduct of officials of states who serve functions for states. It's called functional immunity. It means, in principle, you are immune from prosecution, from civil suit in another state if you were acting within your function. So it's easy enough, in a sense, for the military, high military officials to say, well, I was obviously acting with the authority of the state. I was acting as a military commander, as the chief of the Air Force. Therefore, my functional immunity applies. The difficulty is that immunity doesn't work quite like that. It's just not quite that simple. There are three types of immunity broadly, and I'll just try to sketch them very briefly. There is something called sovereign immunity. This is the oldest type of immunity. It used to attach to sovereigns, kings, queens, right? We've had them for centuries. Sovereign immunity is a very old idea. Sovereigns didn't used to travel very much. Let's take the example of Henry VIII, right? He wasn't traveling around. He didn't have a villa on a Greek island like King Willem Alexander. He mostly stayed at home like a king on a chessboard. And his knights, though, and his bishops, his cardinals, his emissaries, they traveled around the world. They needed a sort of sovereignty as well, because they were needed to conduct his affairs, even to communicate, okay? You didn't have the post, you didn't have the internet. People communicated from king to king by traveling abroad. They needed to be protected while they did that so that they could conduct the king's affairs. So he had immunity, and his emissaries, his diplomats, had immunity. Later than that, we have something called state immunity. States are, of course, historically a relatively new phenomenon, newer than sovereigns. They're a kind of, generally speaking, 19th and 20th century phenomenon. Not every state has a king or a queen. It doesn't have a monarch, but all states have a head of state. And at a certain point, the idea of sovereign immunity extended to these people. So the head of state should also have a type of sovereign immunity. Maybe also the foreign minister, because he's also very head, or she is also very high up, and they do need to travel as well. So they sort of combine a sovereign level of status with a need to travel. The difficulty is more attaching to the question of functional immunity generally. What if you're not the head of state? You're not the foreign minister, you're not the prime minister, you're not the king, you're not a diplomat, but you're somebody else who has functions on behalf of the state. What's your immunity? This, unfortunately, is not very well explained in international law. The idea of functional immunity hangs everywhere. It appears from time to time, but exactly who has it and whether it applies to all of the conduct of a state functionary, that is not so clear. Cedric will talk later about at least one English case in which an English businessman was horribly tortured for 9 days by, I would say, a rather middle-ranking secret police or military official of Saudi Arabia. An English court upheld the immunity of Saudi Arabia and the immunity of this official. He was a lieutenant corporal or something like that. They considered that he'd acted a little heavy-handedly. That wasn't very nice, but basically he was shielded by the immunity of Saudi Arabia. The matter is not that simple. The existence of international criminal law, indeed the law of state responsibility too, points to the fact that for some types of conduct, namely international criminal conduct, you lose your immunity. The people who ended up in the tribunals of Rwanda and Yugoslavia were people with high military or civil status. They were state functionaries. The fact that they were functionaries did not count. They had committed international crimes. They were susceptible to being criminally prosecuted. So it is no longer so simple in the parallel existence with international criminal law to say, well, functionaries of the state are essential to the state's practice. Whatever they do, it's covered by the state's immunity. This is no longer the case. This is one of the arguments that both Cedric and I made in writing about the case. We consider that the Dutch court did not accurately assess the question of the immunity to which these two Israeli officials were entitled. Did I answer your question?
I think that you answered your questions, but in other words, of court didn't say anything about access to justice. It didn't, it
didn't-
dealt with the immunity issue,
Right,
in your words, very insufficiently.
right.
And therefore it didn't answer the questions about the Article 9 story, access to justice. Where do
Exactly.
you go? Which door do you knock on?
Because it treated the question of immunity as a bar to procedure. They
Right.
said, first of all, you have to get through this hurdle. Is there immunity? Yes or no? Yes, there is. So there's nothing more for us to consider. We leave all the other questions unaddressed, even the question of potential jurisdiction under Article 9.
So you don't address jurisdiction because it's too tricky a question, because it requires you to review then the accessibility of Israeli courts. So this,
You shouldn't
Sorry.
touch it. You should touch
It's
the
okay.
thing,
Sorry.
because that's probably, that makes noise for people at home.
So normally you would first touch upon jurisdiction and then you would go to immunity, because the official phrase, of course, immunity from jurisdiction, but putting the cart before the horse in a way. Immunity is a bit of a yes-no story, yeah? Whereas jurisdiction, it's a continuum. So you can have like a bit jurisdiction or no jurisdiction, but for immunity, it's yes or no, a clear answer. There was immunity. And I think the court here overlooked a countervailing imperative, and that was accountability. So what you were referring to, so accountability for international crimes, you see this whole tendency to emphasize international criminal responsibility of individuals. So we're talking here about Israeli generals who are individuals and who could be held accountable before the ICC, but also you could say before domestic courts. But the court didn't go there. It simply applied the classic state sovereignty paradigm. It didn't have a look at other, I would say, newer values. I mean, Kate was explaining that quite well with the birth of the human rights movement, also from 1950s, 60s onwards. The court sort of does as if that doesn't exist. I mean, it's aware of this, but it doesn't believe that it abrogates immunity. So this fits more in the classic international law, I would say, which puts a high premium on state sovereignty and less emphasis on individual rights and the fight against impunity. So a bit disappointed, of course, in that decision.
You wanted to add
Well,
something?
I mean, I think that the subject really points to another key issue in international law regarding accountability, and that's the decision in the 2004 advisory opinion of the International Court of Justice, which made very clear that it's not just Israel which has responsibilities, but also all states. It was very explicit about that. Indeed, after the judgment was handed down, even the Netherlands was very clear that this is something they need to look into. Corporations responded in quite large numbers. Unilever, Vitens, Royal Haskoning, many other companies explicitly decided to pull out their operations in the occupied Palestinian territories directly related to this ICJ advisory opinion. And the Dutch government began, at least in the beginnings after 2004, to align its foreign policy with regard to the advisory opinion. And then it sort of retreated a bit to the background, but I think we need to return to this imperative that the ICJ points to, which of course is existing international law. It just simply affirms existing rules in international law. And that is in relation to this associated regime, which Israel has in place to enforce its occupation, to enforce its regime of control over Palestinians, the conditions under which, of course, the family Ziada was assassinated. That's one really key point. The other, of course, is that, as you alluded to earlier, there is no justice possible within the Israeli courts, at least not for Palestinians. And that is something which also needs to be understood by the Dutch courts in deciding basically to ignore fundamental rules of international law and fundamental facts on the ground. And in particular, of course, the total working nature of the Israeli justice regimes as it pertains to Palestinians.
So I think these classic categories of jurisdiction and immunity should be reinterpreted in light of like these evolving insights that there's such a thing as global values, the fight against impunity and so on. So you don't have to throw them away, the classic principles, but nuance them. So there's more of a, I would say, relative understanding of these state sovereignty related concepts, like this Article 9 to which you referred, which does not as such talk about human rights, you can interpret it in light of human rights, in light of the obligations which the Netherlands has on the basis of advisory opinion, but more generally, the Netherlands is a signatory to so many human rights treaties. So you have to interpret your own domestic norms in light of the commitments you have undertaken at the international level. So I think that's the challenge now, and is the Court of Appeal willing to take up that challenge, to be a bit more progressive than this let's say, rather conservative district court.
And then maybe just to be a bit clear to those at home who are not lawyers, I mean, what the ICJ was explicitly saying is that indeed all states, including the Netherlands government, has obligations to ensure compliance with the type of law that we've been speaking about here, international humanitarian law and international human rights law, including also, of course, the Palestinian principle around self-determination. So that's precisely the kind of obligations that the Netherlands has.
Just one little comment I wanted to add. A good place to start for the Dutch Court of Appeal would be not to apply the idea of immunity in a sort of automatic way. There have been several voices within Dutch politics. There is also, you could argue, within Dutch domestic law, provision that the matter of immunity is not to be implied in an automatic or a blanket way. It's to be considered on a case-by-case basis. The European Court of Human Rights, although it has allowed to pass a number of cases in which immunity was at issue, and it maintained that states who had upheld the immunity of foreign states officials had not violated anybody's rights to a fair trial under European law. Nevertheless, in their own guide to the interpretation of what it is to offer a fair trial, urged that the question of immunity and the question of the availability of alternative jurisdictions should be considered on a case-by-case basis. Mm-hmm. It cannot be considered legitimate to have decided a case like Ismail Ziada's without having explored the details to at least some extent. In this sense, it's quite a remarkable decision, remarkably disappointing decision, as Cedric has mentioned. There is plenty of ground in Dutch national practice, documented political perspectives and legislation to allow the court, to require the court to explore the case and the question of immunity before it decides to toss it out. That would be a great place to start.
That seems clear. I would like to go back to Issam. Issam, are you still with us?
Yes.
Yes. I would like to know, just moving a little bit away from the legal details and the legal aspects. What does this case mean in Gaza? Are people following the case in the Netherlands? What's the importance and the relevance? I mean, the relevance is clear, but how are people talking about the case? Are people following the case? What is the situation with respect to
very much people are following the case. The case of Ziada, as well as the ICC development. And again, what's missing is this thirst to justice. Finally, we're talking about human beings who are and should be protected. And I think one of the very serious issues that all the time should be borne in mind, not only for legal experts, but also for politicians, that if a series of violations and the execution of war crimes, denial of justice continues, this would kill any chance for hope. Then if you lose hope, the act will be then irrational. And there should be a common interest in pushing for justice. And I think it's very difficult to put aside the issue of impunity. What has been just explained, I think very interesting, but I think impunity should not at all. And one could easily invoke here either the Rome Statute or even the Geneva Conventions themselves, and the recent history of Europe. I mean, common Article 1 of the Geneva Convention is very clear that the obligation is not only on the state party, but also a third party should it's under the obligation, the legal obligation of the state party to ensure a third party would not violate the Geneva law, the Geneva principles. Impunity is the chronic problem behind the atrocities, behind the war crimes that have been committed, not only here but everywhere, as you know. And the Ziada case could be the just one case where Palestinians could succeed, as you know, and one should also be frank here. In many occasions where Palestinians and other victims, maybe from other conflicts, would succeed to approach a national court of universal jurisdiction, next day the law to be changed to make it mission impossible, not only for victims but also for others. This is how things are being politicized. The ICC, for example, which is the last resort for victims, which is the mechanism of civilized nations that has established and should be respected, has been sponsored, for example, by Europe heavily, not only funding, but also to ensure that we have white smoke by the end of the day. And we have the ICC. And then when Palestinians approach the court, next day, I mean, they were threatened when the state of Palestine joined the Rome Statute. Next day, the American administration had managed the PA by, freezing the funds allocated for Palestinians, for the PA. And the Israeli government as well has frozen the tax revenues collected by the state of Israel on behalf of the Palestinians. And who politicized the court then? It's very clear when President Trump's administration have taken this extreme step by consider the prosecutor Fatou Bensouda and her IDs as classified. They were put on the list of classified with other measures that has been taken, and they were direct threat to the judges, the Attorney General's office, and by the end, the court is not an end by itself. The court is a civilized mechanism that might achieve a little bit justice for some victims, and the most important thing, to ensure that the scenario will not be repeated. And again, one should go into details why the Hague and why for Ziada to go for the Hague. And very interesting issue and the development that took place in the state of Israel is the amendment of the state liability law, the tort law of in the year 2012. And I'll read here that the law is the primary legal obstacle currently faced by Palestinian victims in the Gaza Strip who are bringing civil claims before Israeli courts. Amendment 8 was passed into law by the Israeli Knesset on 16 July 2012, which retroactive application to 12 September 2005, and gives courts the power to dismiss civil cases at the preliminary stage without hearing witnesses or considering evidence. If the damage for which the claim was submitted occurred as a result of the Israeli military's combat action, the amendment also expanded the definition of a combat action to any warfare operation. And this is quite interesting here, including any action against terrorism, hostilities, or uprising, and any preventative action against terrorism, hostilities, or uprising is combatant in nature. Considering all circumstances, including the action's purpose, geographic location, or the threat of the operation forces. Amendment 8 fails to distinguish legitimate military actions from negligent executions of military operations. To swear complete impunity for soldiers and officers to suspected war crimes, and enables the state and the Israeli military to evade its legal obligation under international law to provide reparation and compensation for the damage resulting from its operations in Gaza. The restrictions on freedom of movement due to Israel's policy Israel's closure policy of Gaza means that lawyers living in Israel that are hired by Palestinians, by the way, Palestinian lawyers from Gaza were banned to appear before the Israeli courts since the year 1996 until today. So the only way to do the homework is through Israeli private lawyers. Gaza are not permitted to enter the Gaza Strip to meet their clients, take witness statements or collect and verify relevant evidence, nor can the Palestinian clients go to Israel to meet the lawyers and attend court hearings. As a result, the lawyers meet difficulties in collecting the evidence necessary for building the legal case against the Israeli military. In addition, since June 2007, the Israeli military has refused permissions to Palestinians involved in civil cases to appear in court and to testify despite the issuance of court orders. This results in the effective dismissal of such cases and the absolute denial of justice. The authorization of official documents, including powers of attorney, inheritance and death certificates, medical reports of injuries, and other court-required papers must be carried out within Israel. Authorization done by Palestinian government institutions or validated by POSES is the consideration due to Israel's closure blockade policy of Gaza. Claimant from Gaza must hire a lawyer in Israel to take the case in court, yet the claimant is not able to access the court in Israel in order to sign over the necessary power of attorney. As recently as May 2015, Al-Mizan's request for permits for a family with an ongoing lawsuit in Israel to access Erez crossing and meet with their lawyer was rejected by the Israeli authorities. As a result, the case could be dismissed on the grounds that the powers of attorney will not be signed in the presence of the Israeli lawyer representing the victim. The restrictive statute of limitations requirements in accordance with the Israeli tort state liability law, stipulate that any non-Israeli victim suffering damage as a result of the Israeli military's combat action in occupied Palestine must submit a complaint to the Israeli Ministry of Defense within 6 days. So 60 days since the injury, it should send a notification to preserve a right for 2 years. To reserve a right, it files civil claim within 2 years. If such a claim is not submitted, in most cases, the victims loses the right to access the Israeli courts and can no longer demand effective remedy for their damages. Importantly, the period limitation of most other civil claims submitted to the Israeli courts is 7 years, and no preliminary complaints are required. The court guarantees, which is quite also important, the court guarantee that Israeli courts requires each individual victim to pay is on average the equivalent of 5,000 euros. It is required to open a case, is paid to offset the state of Israel's defense costs if the court doesn't rule in favor of the victim. Israel justifies this court expenses as applicable to all foreign nationals and is a legitimate measure to ensure that legal costs are covered in the event that the claimant is unsuccessful. This is just part of the problem. Just to let you know about our work regarding the complaints that we have submitted. We have submitted some 120 criminal complaints into the most serious cases indicating violations of international law, and there were 0 criminal prosecutions in any of our cases for the 2014 assault. For all of the 500 plus cases that the MAG dealt with concerning the 2014 assault from us, from the Palestinian Center for Human Rights and some other groups, there were also 0 indictments and 0 convictions of killings or serious injury, in other words, for serious crimes. The only indictment were for 3 soldiers in one case who were convicted of theft. So it's more discipline-based investigation rather than seriousness of war crimes that have been committed. A low level or common crime, not a serious crime. In other words, the Israeli authorities delivered complete impunity for their military commanders and government leaders who are responsible for killing over 1,000 Palestinian civilians within 51 days in Gaza. When there is targeting of civilians and civilian infrastructure, when the cost of civilians is so high that it's clear that international law has been very seriously violated, accountability is necessary. But those incidents are not dealt with seriously by Israel, not in the military investigation system, and then who investigates whom? The Attorney General investigates the officers. It's all the establishment. It's the military, not in the court system and not at the governmental level. For many years, Al-Mizan engaged in good faith with the Israeli investigative mechanisms with the aim of facilitating access to victims' rights. But the result was always the same: impunity. Sure, Israel has an investigation system, but that system does not function to deliver justice. It functions to shield Israeli military and governmental perpetrators. So the issue of accountability is very serious, and one could speak. I remember an article written by years ago by the military advocate general, and he said clearly that Israel, as a democratic state, respects the international law, is distinguished and should distinguish between what is legitimate and what's lawful. Legitimacy is sort of PR, public relations, while law should be respected. So attacking, for example, a mosque could be illegal target, but could be illegitimate. But here, illegitimacy or legitimacy is something for PR, but we abide by the law. And back to the point that was raised regarding collateral damage. You could kill 1,000 people because there is a legitimate target, a terrorist somewhere inside. So those who were killed and destruction and, is only collateral damage. Can this be tolerated? Is it? International law itself is very clear in this, but then it depends on the way that we put it. As you know, when it comes to the Israeli practices in the occupied territories, politics is there and balance is there. And I think no one is doing any good for Israel by tolerating this. Law should be respected. And again, for the ICC, we don't care who might be brought to the court, regardless of nationality, religion, whatever. Those who violated the basic principles of Rome should assume the responsibility on this, regardless. It's not a one-way track. And again, just to make it easy, which people all the time love to hear. But finally, this very chronic way of dealing with protected civilians and this entity, I think it's very, very, very serious, and again would prejudice dramatically peace and security in this part of the world. So that's why justice is something should be all the time bear in mind. The alternative for it is killing any hope and then opening the situation for even worse than what we have witnessed so far.
Thank you, Issam, very much for this clarification. I think it makes the situation very clear on legal, practical, and political level. We have a couple of questions from people at home. One question that maybe links up to your last remarks about hope. Mr. or Mrs. Palmer asked in relation to this case and the issue of Palestinian civil rights more broadly, do you see any potential positive developments in future American foreign policy that could break with the tradition of helping to put Israel above the reproach on the international stage? So maybe you want to say something. Maybe I can ask, may I ask Jeff to say a little bit about this? Do we see any openings in a new American foreign policy?
No, not fundamentally. I mean, the United States is still, even under Biden, fundamentally opposed to the idea of the ICC. I mean, it's made very clear how much it objects to the ICC exercising jurisdiction, not in quite such bombastic terms as the previous administration, but still, I mean, I don't see that we're going to see, I think we will see potentially efforts to block the ICC exercising jurisdiction, again, not in the same bombastic terms, but is it going to fundamentally change? No. I think the only thing that could provide an opportunity are the kinds of cases that are being brought by the Ziyada family in relation to this matter. In civil courts, this is where there's at least been an ability to make known to the rest of the world what the heck is going on there. And that's actually what's really important about these cases. Just as in South Africa, where I was working at the beginning of my career, and it was very clear that we were going to lose these cases, that actually mattered less than the fact that these cases revealed how the Israeli regime operates. So actually that has already succeeded with regard to this case. It's made the world know that the Israeli military committed these acts. And yeah, so in the court of public opinion, I think that one can safely say that guilt has already been attributed, but that's not enough, obviously, for the families. And that's why the case is so important. What is, of course, totally inexcusable is the fact that, and you expect it a bit more in the United States, perhaps, but at least in the Netherlands, you expect a higher standard of respect for international law. You expect a higher standard of this form of necessity that was referred to earlier. And yeah, I mean, so in that regard, I think it is really essential that we look at countries like the Netherlands, which do have much more functioning justice systems and the possibility, whereas we heard in Israel, there's absolutely no possibility at all. And that's a really important point that we need to underscore here, is that there is no possibility for justice. So there's no avenues for justice within Israel, within countries that are very solid friends of Israel, such as the United States. And that's why the Dutch courts really are obliged by principles of international law and by principles of justice and legitimacy to allow this case to go forward.
These are definitely not crazy claims. I mean, the claims could be viable in Dutch courts, as we explained, under a forum of necessity and under a progressive interpretation of the immunity versus accountability debate, linking up to what the International Law Commission actually said in 2017, that immunity does not extend to international crimes. Now, the court at first instance said, well, this is progressive development of the law. We don't have to look at that. I'm not quite sure. Look actually at the practice of states. Look also at the practice of Dutch courts, which have routinely exercised universal jurisdiction, thereby implicitly rejecting state immunity or functional immunity. And Dutch people also often look at evolutions in Germany. There's now a German court case, court decision, Mr. Ziada has heard about this January 2021, where the highest court in Germany said, well, we don't accept immunity when we talk about international crimes. In the case, it was the war crime of torture. So the highest court in Germany. So I would really recommend the Court of Appeal in The Hague to look across the border to such an authority, clearly listing a lot of state practice and a lot of recent evolution. So this is also my hope regarding what the Court of Appeal in The Hague will decide.
Okay.
Yeah, and I'd like to juxtapose this with the extraordinary rationale that is given for upholding states' immunity at the moment, including by the Dutch court in Ismail Ziada's case in the Dutch district court. It said that it was legitimate to uphold immunity because sovereign immunity serves two legitimate purposes. Observing it observes a long-standing customary, a principle of international customary law. In other words, we've been doing this for a whole long while. People are used to this, so we should keep doing it. And the other rationale, even more remarkable, when you consider what Issam has explained about the profound asymmetry of the legal relationship between Palestinians and Israelis, the other rationale is, wait for it, comity between states, friendship between states. Now, in my ears, after what we've heard and what we know about this case, this is an extraordinary rationale to offer. For the sake of comity between states, we should observe state immunity and derive from it the immunity of pretty much a whole lot of other people, almost whatever they do. That is an extraordinary argument to oppose to the argument that impunity is being resisted on many fronts in international and national law at the moment, including in Holland, very recently in Germany, at the ICC, and so on. Bear in mind, finally, that if it's states who are supposed to protect their civilians when terrible things happen to them, the Palestinians don't have one. There is no state of Palestine that can protect them. Palestinians are stateless persons. In this case, Ismail Ziada also has Dutch nationality. Therefore, if he has any state at all, it's Holland. Issam has explained the massive and continuing efforts that Palestinian lawyers have gone to defend the rights of their citizens, their people. But bear that in mind, a stateless population dealing with an impunity on the scale that you've been hearing about, and having juxtaposed to that the idea that it would be nice for the friendship of states to maintain immunity, it just, what can I say? It's not a good look. It's not a very good balance of principles of justice.
But to maybe offer just
Can
one
I,
smart
just
clarity.
before you, I give you the floor. We have 10 more minutes left. If there are people who have questions, please put them in the chat. There were a number of questions of what I think answers were given. So if you have any pressing questions, put them now in the chat while Jeff is talking.
Just one small point. I mean, I would disagree that there's no Palestinian state. I would actually think there is a Palestinian state in law, but it doesn't function as a state because it's totally under the control of the Israeli military and the government, which of course denies them any possibilities to act like a state. So there is absolutely in law a state, but it cannot offer the kind of protection that most states ought to. And that's of course why this case is utterly essential. But it also makes very essential that the ICC intervene in order to affirm at least the state-based jurisdiction, which it has over the crimes in Palestine. So I just want to offer that little small clarification because we've been talking about multiple jurisdictions here. So.
Isam.
Yes, thank you. Well, regarding the question, I mean, do we expect a change or some sort of different engagement from the side of the American administration? I remember, and I invoke here Gideon Levy. We were together actually years ago in Utrecht. And I remember he said something. He began his speech by saying, with the very strange question, have you ever heard of a half-pregnant woman? And the public were, you know, smiling. I mean, never heard of a half-pregnant woman. She said exactly, it's the democracy. There is no half democracy or quarter democracy. And same thing I would say is exactly justice. There's no half justice or a quarter justice, either justice or lawlessness, either justice or the law of jungle, which is quite costly on everyone. So we are creating the factors to more irrational actions or enmity in this regard. But I'll take the talk a little bit in 2 minutes for politics. I think the whole rules of engagement, the engagement with this part of the world, where people just, you know, when Oslo was established, it has been heavily backed, and we were critical because unless the process was not based on rules of international law, it would lead to very different intentions, very different facts. Now, under this way of engagement by different players, talking about international community, I mean, the harvest is very, very sad. The harvest, I mean, it's a harvest of sins by the end of the day. And again, Palestinians have been transferred systematically in a very organized way by the state of Israel to transfer them from a nation to communities. This is one thing. Fragmentation of the geography and the demography is very clear. This would, you know, deviate from the sovereign interest of having two-state solution. So now Israel is a state of apartheid, as it's very clear, and without reconsidering the whole engagement, the legal, the political engagement with this part of the world, I think the worst is definitely coming, and it's a moment of truth where rules of international law this time should be respected. They are not rules for PR to be, you know, sort of civilized international law, where here very important, especially protection, and I think the facts have been created on the ground that are irreversible. Settlements are everywhere. I mean, on the eve of Oslo, the number of settlers were 100,000. Now it's more than 700,000. While international community was watching, no one would claim that she or he did not see or hear what's going on. It's widely covered. They have access to facts on the ground. I think what is needed is to change the rules of engagement legally, politically. Tolerating practices is very destructive for the whole region, not only for the Israelis and the Palestinians. And I think the Gaza, West Bank, Palestine is the backyard of Europe. It's not as if we have to cross the Atlantic. It's just, if there is a will, there is a way. And that's why Palestinians are very much following the case of Ziada, because it's just a symbol. It's just a model for international community to reconsider the whole engagement, legally speaking. And we do respect the independence of the court, and we trust the court, and we trust the system. But finally, it's the whole issue. Law is one thing, but also other engagements also should be reconsidered. Thank you.
Thank you very much. I think that is very, very clear. One question from one of our participants is, are there any useful actions that observers in the general public can take to support this case? Any suggestions here in the panel? Talking about legal mobilization.
Well, I mean, what I said earlier, you know, the fact that these cases reveal what is going on is really perhaps the most critical part in my eyes of bringing these cases in the first place. It gives legitimacy to the rule of law, to the rule of international law, as well as domestic law. So that, of course, is in and of itself of value. But the fact that it, again, lets people know what's going on in terms of the facts on the ground is absolutely critical. So yeah, that I see as the most important. And there are, of course, legal issues at stake. There's no doubt about that. And they're really important legal issues at stake, and they must be argued. But to allow, you know, to stop the case from even proceeding to the pertinent facts and to the pertinent legal issues which need to be discussed is just really, you know, inexcusable and in direct violation of the Dutch government's obligations in international law. But I've made that point already.
Okay, I would like to thank you, Issam, for being with us from Gaza. Apologies for the technical problems we had in the beginning, but I hope for everybody it was clear to understand, and I think your message came across very clearly for us, at least here in the ISS. Thank you to the panel. Thank you for the people here in the room for being with us. Thank you, people at home. As said, next Thursday is the hearing in the case. We, of course, look all forward to finding out what the court will decide. One question from the audience is, when will the court decide? Ismail, do you have any ideas?
Till January. 4 months.
4 months. So so it is a couple of months, but the court in the first instance took some more time to translate the decision in English, which of course was good, so to be able to spread the decision among a larger audience. And I expect that they will do that again, but we'll see. So we can only be vague. It will be a couple of months, but it will be very important. Hopefully there will be possibility of audience being in the room. That has not been decided due to COVID measures that will be lifted 2 days after the court hearing, which is a real immense pity, because we think this is a case of a public importance and should not be only viewed by 2 people in the audience. So what we do from our side, from the Nuwanich Foundation, we publish about it, we support the case, we make sure that there is a good database on our website with all the court documents, all the statements, so that we at least can follow the case through this database. I can see that Mr. Roger Waters is also with us. May I take this opportunity on behalf of Ismail Ziada for your endless support of this case. Very, very important that you're supporting this very unique case, and I'm very happy to see you here, although it's very tiny, small, like a postzegeltje. Thank you for being with us. Thank you for your support. There you are. We all see you now. Is there one last word for Roger Waters?
Well, our friend in the Dutch football shirt was asking, or somebody was suggesting, what the public might do, you know, and I'm just holding up signs to my microphone because I've been muted throughout all this. furiously trying to unmute myself most of the, not furiously, enthusiastically trying to unmute myself. Do what you've been doing. Take to the streets, become the Humboldt 3 million, not the Humboldt 3. Support BDS. Make as much noise as you can in everybody's ears, which will be an amplification of everything that has been said at this table today from our friend in Gaza and from all of you there. That's what you have to do, because we all understand that the laws written by the sovereigns handed down to the ruling classes and the corporations are not the laws under which we, the people of these United Nations, are prepared to live for the rest of time, or for as long as this planet is allowed to exist. So that's all I have to say. But thank you so much. This has been very instructive, and I will be watching on September the 23rd to see what happens.
Thank you very much.
Okay.
We will make lots of legal noise. I think that's what we
That will be very good. So my love to the Ziyadas, you know, as always.
We will. He sends his love back. He's here 2 meters from us. And
Okay,
he's
great.
invisible.
Ismail.
Okay. This is
Go
what
for it, brother.
Thomas does. Thank you very much. Thank you all.
Thank you. Thank
We
you.
have to leave this room. Goodbye to everybody.
Bye.
Bye.
Bye-bye.